Mbando. And the applicant is represented by Mr. Donald Deya and Ms. Sarah Peters. Application number 019 of 2018, Center for Human Rights and Others, and the United Republic of Tanzania. The respondent is represented by the advocates aforementioned in the previous matter. That's the respondent. And the applicants represented by Ms. Matilda Laseko Koko, Dr. Ms. Chipo Irene Rushwaya, Mr. Michael Gian Nyako, Mr. Fulgence Masewa, Advocate Sarah Bosha, who is joining virtually. And the last matter, Honorable President, is Boniface Alestid and the United Republic of Tanzania. The respondent is represented by the aforementioned advocates. I thank you, Madam President.
In application number 034 of 2019, Angel Guesan versus Republic of Cote d'Ivoire. This judgment will be read by Honorable Justice Ben Saoula in French.
Merci Madame la Présidente. Donc, en l'affaire Nguessan Yao Andjé contre République de Côte d'Ivoire, requête numéro 034-2019, arrêt du 5 février.
Ruling of 5 February 2025. The court composed of Imani D. Aboud, President, Modibo Sako, Vice President, Rafa Ben Asho, Susan Menge, Tijulani Chizumila, Shafika Ben Saula, Blaise Chikaya, Stella Ayanuka, Dunisa B. Nsebesa, Dennis D. Ajay, Duncan Gasaga, judges, and Robert Eno, registrar. Facts of the matter. It emerges from the application that the applicant and 2 other persons who are not party to this application were arrested for armed robbery and were put in custody. On the 1st of March, they were declared guilty of these charges and sentenced to 15 years imprisonment by the Court of First Instance of Congo by judgment 016/59/2013. Following the appeal, the Court of Appeal of Abidjan rendered a judgment confirming the judgment number 61 of 8 February 2017, hereinafter referred to as judgment of the Court of Appeal of Abidjan. The applicant declares that at all stages of the proceedings, he admitted guilt of all the facts. The applicant states that for reasons beyond his will, he did not go on appeal because the judgment of because he did not benefit from the assistance of a counsel. He did not know about the existence. He adds that in any case, the matter would have been fruitless considering the current state of the situation in Cote d'Ivoire. Prayers of the parties. The applicant prays the court to order the following measures: presidential pardon, the commutation in due form of his 20-year prison term to a lesser term, conditional release, an out-of-court settlement, and financial compensation for the damage suffered as a result of the unfair court rulings against him. The respondent said, praise the court, as a matter of fact, to declare the application inadmissible for violation of Articles 55, 6, and 6 of the Charter on the merits find that the applicant does not prove the alleged violations of rights. Accordingly, dismiss all the claims as unfounded. Make an order as to the cause. After deliberations on jurisdiction, the court declares that it has jurisdiction on admissibility. After deliberations, upholds the objection to the admissibility based on the non-exertion of local remedies, declares the application inadmissible. So the operative part will be as follows on cause. The court unanimously on jurisdiction declares that it has jurisdiction. On admissibility, upholds the objection to the admissibility based on non-exertion of local remedies, declares the application admissible, and on cause orders that each party shall bear its own cause. Signed. All the judges of the bench cited above, including Dr. Robert Eno, the registrar, done in Arusha this 5th day of February in English and French, the French text being authoritative. That it
His judgment is going to be read by Honorable Menge in French.
Merci, Madame la Présidente. Affaire Hunge, Eric Noudenouo contre République du Bénin. Requête numéro 020/2020. Arrêt du 5 février 2025. La Cour, composée de Imani D. Aboud, présidente, Modibo Sako, vice-président, Rafa Ben Achour, Suzanne Menge, Tujilan R. Chizumila, Chafika Ben Saoula, Blaise Tikaya, Stella I.
Anukam, Dumisa B. Nsebesa, Denis D. Ajayi, Duncan Gaswaga Georges, and Robert Eno, registrar. The facts of the matter as follows. It emerges from the application that on the 29th of July 2014, the SBEE signed a tax assistance contract with tax expertise, the purpose of which was to enable SBEE to make savings on its tax obligations totaling 7,334,182,596 CFA francs. This is for the 2013 tax year. The applicant further avers that following that the SBEE's failure to perform the contract, he sued it before the Cotonou Court of First Instance, which dismissed the suit by judgment number 07/2017 of 22 December 2017. The applicant further avers that he appealed the court's decision. However, at the time of filing this application, the Court of Appeal of Cotonou had still not handed down its decision. Rather, it had adjourned the case severally. This set judgment was only made available to his lawyer on 2nd November 2020. He claims that his rights as protected by international human rights instruments were violated by the national courts in the course of these proceedings. The applicant further states concerning another case that he granted a loan of 10 million CFA francs to one Edouard Win Uru, allegedly a civil servant of the respondent state. He claims that the said Edward Wynne, who will fail to pay the said sum despite numerous reminders, which, in his view, engages the responsibility of the respondent state insofar as the events took place on its territory. These are the prayers of the parties in this matter. The applicant prays the court to declare that it has jurisdiction, find the application admissible, find that the violations of his rights protected by Articles 1, 4, 5, 7, 14, 15, and 16 of the Charter are founded. Articles 2, 3, 7, and 14.1 of the International Covenant on Civil and Political Rights, Articles 8, 10, 17, and 23 of the Universal Declaration of Human Rights, and Articles 2, 6, and 7, and 11 of the International Covenant on Social and Economic Rights are established, and that the respondent state is liable for those violations. He further calls on the court to order the respondent state to pay the applicant through its relevant structures compensation for loss of property rights and or a decent standard of living in the amount of 5 billion 58 million CFA francs within 1 month of the delivery of the court's decision, in accordance with the requirements of Chapter 9 of the United Nations Resolution 60/147 of 16 December 2005, and in line with the jurisprudence of this court and the Permanent Court of International Justice, according to which the respondent state responsible for the violation must endeavor to wipe out all the consequences of the unlawful act and re-establish the state which would probably have existed had the said act not been committed. He further prays the court to order the respondent state to pay him interest on the damages for the loss of his right to property and or his right to a decent standard of living at the annual rate of 12% capitalized monthly from February 2015 until the date of full compliance with the court's decision. He further prays the court to order the respondent state to pay him the sum of 250 million CFA francs as moral reparation. He prays the court to order the respondent state to pay the applicant's legal fees for the exercise of the rights of the defense in Benin and before the court of first instance, before this court, as well as the costs incurred in respect of documents and of proceedings upon submission of supporting documents. Order the respondent state to pay in view of its failure to comply with previous decisions of the court, to pay a lump sum interest of the award in this amount of 300 million CFA francs for failure to comply with the court's decision from the date of notification of this decision until it has completely complied with the said decision. Finally, a prays the court to order the respondent state to pay the cost. For its part, the respondent state prays the court to declare that it lacks jurisdiction, declare the application inadmissible, find that the applicant's claims are unfounded in their entirety, dismiss all the applicant's claims, and order him to pay the cost. Let's move on to the operative part. For this reason, the court unanimously on jurisdiction dismisses the respondent state's objection to its material jurisdiction and declares that it has jurisdiction on admissibility upholds the respondent state's objection based on non-exertion of local remedies, declares the application inadmissible. On cost, the court decides that each party shall bear its own cost. Signed, all the judges mentioned earlier above, and Robert Eno, Registrar of the Court. Done in Arusha this 5th day of the month of February in the year 2025 in English and French, the French text being authoritative. I thank you.
President.
Sénaphorie contre République de Côte
Republic of Cote d'Ivoire. February 2025. The court, composed of Imani Aboud, President Modibo Sako, Vice President Rafa Benashur, Suzanne Menge, Tujenan Chizemela, Shafika Ben Saula, Blaise Chikaya, Stella Anukam, Demisa Nchebeza, Denisa Ajay, Donkam Gaswaga, judges, and Robert Eno, Registrar. In this matter, the applicant avers that in 1995, following a fire outbreak in the premises of the treasury of Giberua municipality, where he worked as cashier, he was accused of willfully destroying accounting documents and embezzlement of public funds. He was subsequently relieved of his duties by the Minister of Finance and Economic Planning and sentenced to 10 years imprisonment by the Ganywa Court of First Instance. He avers that the Sénat Trésor, of which he was a member, did nothing to trigger the solidarity, visitation, mutual aid, and union action clause to his benefits. The applicant contends that things would have been different for him if Senate C had not failed to honor its trade union obligation towards him. On 13th June 2018, he filed a complaint with the Abidjan Court of First Instance at Plateau against the trade union, seeking an order compelling Senate Trésor to pay him the sum of 34 billion CFA francs in damages. On 4th June 2020, the Abidjan Plateau Court of First Instance ruled that the defendant, the trade union, was legally established only on 17th March 2004, that is subsequent to the event, and could therefore not appear as a defendant. Consequently, the court declared the application admissible on the grounds that Senat Trésor lacked funding as defendant. Believing the decision of the African Court of First Instance denied him justice, the applicant brought the present application before the court. Parties to this matter are praying for the applicant. Praise the court to order the respondent state to take the following measures. First, pay him as soon as possible the sum of 420,000 $120 million US dollars as compensation for the extra patrimonial harms he suffered and continues to suffer as a result of the violation of fundamental rights. Secondly, implementation of the judgment of the African Court in the present application within a maximum of 6 months of delivery, failing which the state shall pay him default interest calculated on the basis of the rate applicable to the Central Bank of West African States throughout the period of the default until the full payment of the sum due. Thirdly, submit within a maximum period of 6 months from the date of delivery of the African Court's judgment in the present application a report to the African Court on the status of implementation of the extra patrimonial reparation awarded. The respondent state did not participate in the proceedings and that did not make any prayers. The court, having established the absence of the respondent state, decided as follows: unanimously decide to render the judgment by default. On jurisdiction, declare that it has jurisdiction. Admissibility, declares the application inadmissible for non-exhaustion of local remedies, and on costs, declares that the applicant shall bear his own costs. The judges and the registrar, as referred to above, have signed on this done at Arusha this 5th day of the month of February of the year 2025 in French and English, the French version being authentic. I thank you.
Republic of Tunisia. Yes, the court will be reconstituted. Judge Benashu is going to recuse himself because the case is against his state. This decision is going to be read by Honorable Justice Ben Saula in Arabic.
Merci Madame la Présidente. قضية إبراهيم بن عبد الحميد
What is the case, Tunisia?
On the establishment of the African Court on Human and People's Rights, hereinafter referred to as a protocol, and Rule 9 of the Rules of Court, hereinafter referred to as the rules. Judge Rafa Ben Ashu, member of the court and a national of Tunisia, will not hear the matter. The subject of the application, facts of the matter. It emerges from the file that on the 14th of July 2017, the applicant seized the court of first instance of Arena, herein referred to as the court of Arena, in a matter against a public official named Ali Fadel. The latter gave the impression that he could be recruited for the post of lecturer at the secondary level after paying 2,000 Tunisian dinars. He was heard by the police of Ariana, and that was on the 19th of October 2017. On the 9th of March 2018, the applicant submitted a request to the Tunis Court of Appeal, public prosecutor seeking an update on any action taken by the public prosecutor's office. In respect of his complaint, the applicant avers that he did not receive any feedback to his request. He further avers that on the 11th of April 2018, he referred the matter to the Inspector General of the Ministry of Justice and still did not receive any response on the 31st of May 2018. The Ariana Court of First Instance of the public prosecutor had the application and the applicant and his lawyer rather, but no further action was taken regarding the complaint. Finally, he avers that on the 19th of September 2018, he lodged a complaint with the public prosecutor of the Cassation Court, who did not take any action. As regards the prayers of the parties, the applicant prays the court to declare that it has jurisdiction, declare the application admissible, hold that the alleged violations are founded, order measures to prevent the continuation of injustices and violations already committed by the public prosecutor's office and to remedy them, provide legal aid to enable him attend the hearings and to cover travel and accommodation costs as he is indigent. Order the respondent state to take appropriate measures to avoid reprisals against him for having sought justice before the African court, and render a decision on the phenomenon of states parties to the protocol exceeding legal time limits, which adversely affects the rights of victims in Africa. As for the respondent state, it prays the court to declare that it lacks jurisdiction, declare that the applicant failed to exhaust local remedies, declare that the respondent state did not violate any human rights, and declare the present application inadmissible in its form and on the merits. For the operative part, for these reasons, the court unanimously on jurisdiction dismisses the objection based on material jurisdiction, declares that it has jurisdiction on admissibility, upholds the objection to the admissibility based on non-exhaustion of local remedies, and declares the application admissible on cost, orders that each party should bear its own cost. Dismisses the material jurisdiction, dismisses the objection to its material jurisdiction, and orders that each party shall bear its own cost. Signed, all the judges of the bench mentioned above, and Dr. Eno as registrar, done at Arusha this 5th day of February in the year 2025 in Arabic, English, and French, the Arabic text being authoritative. Thank you, Madam President. Of the court.
20th of February 2025, I'll read parts of the judgment in the matter of Ladislao Shalula versus the United Republic of Tanzania in application number 003/2018. The court is composed of Mundiso Sako, the Vice President, Rafa Ben Ashur, Susan Menge, Tujilane P. Chuzmila, Shafika Ben Saula, Blaise Chikaya, Stelai Anikam, Tumisa Bin Zebeza, Dennis Diajay and Dangen Kaswaga were judges, and Robert Ino, the registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, establishing the African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9(2) of the Rules of the Court, hereinafter referred to as the Rules, Justice Imani Diabo, the President of the Court and the National of Tanzania, did not hear this application. On the facts of the matter, it emerges from the record that on the 31st of March 1991, the applicant, who was traveling with a friend on foot to Kanyega gold mines, murdered Mr. Selemani Abdullah Rai, whom they met on the way by using a machete in a bid to rob him of his possessions. The applicant and his friends were subsequently arrested and charged with murder of the said Selemani Abdullah Rai. However, the applicant's friends was released 2 years later after the prosecution filed a notice of nolle prosequi in his respect. On the 7th of March 1995, the applicant was convicted of murder and sentenced to death by the High Court of Tanzania, sitting in Sumbawanga, Rukwa region. The applicant appealed the High Court's decision to the Mbeya Court of Appeal, and on the 10th of June 1999, the latter court rejected the appeal in its entirety and upheld the conviction for the murder as well as the death sentence. The prayers of the party in this application are as follows. The applicant prays the court to declare the application inadmissible, to set aside the conviction and death sentence imposed upon the applicant, and remove him from death row and release him from prison. Order the respondent state to pay him and his close relatives damages as reparation for the material and moral harm suffered. Order any other measure that the court deems appropriate in the circumstances. The respondent state prays the court to grant the following orders with regard to the jurisdiction and admissibility of the application. 1. Declare that the court lacks jurisdiction to adjudicate the application. 2. Find that the application does not meet the admissibility requirements stipulated under Rule 40(6) of the rules. 3. Declare the application inadmissible. And 4. Dismiss the application. On the merits and reparations, the respondent state prays the court for the following orders. 1. Find that the respondent state did not violate the applicant's rights provided under Article 2 of the Charter. 2. Dismiss the applicant's prayer for reparations. And 3. Order the applicant to bear the cost of this application. The court examined all the submissions and came to the operative part, which reads, for these reasons, the court unanimously on jurisdiction dismisses the objection to its material jurisdiction and declares that it has jurisdiction. On admissibility, it dismisses the objections to admissibility based on non-exertion of local remedies and the failure to file the application within a reasonable time. Declares the application admissible. On merits, the court holds that the respondent state did not violate the applicant's right to non-discrimination guaranteed under Articles 2 of the Charter. Court holds that the respondent state did not violate the applicant's right to equality before the law and equal protection by the law guaranteed under Article 3 of the Charter. The court holds that the respondent state did not violate the applicant's right to a fair trial protected under Article 7, brackets 1, brackets C of the Charter. Now, by a majority of 8 for and 2 against, the court holds that the respondent state violated the applicant's right to life protected under Article 4 of the Charter by reason of the mandatory imposition of the death penalty on him. Court holds that the respondent state violated the applicant's right to inherent dignity protected under Article 5 of the Charter in relation to the method of execution of the death penalty, that is, by hanging. On reparations, firstly on pecuniary reparations, the court dismisses the prayers for reparations for material prejudice. The court dismisses the prayers for reparation for moral prejudice suffered by indirect victims. The court orders the respondent state to pay the applicant an amount of 300,000 Tanzanian shillings as reparation for moral prejudice suffered. Court further orders the respondent state to pay the amount indicated above tax-free within 6 months of service of this judgment. If it fails to do so, it shall be liable to pay default interest calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delay in payment and until full payment of the sums due. On non-pecuniary reparations, the court dismisses the applicant's prayer for release. Court orders the respondent state to vacate the death penalty imposed on applicant and remove him from death row. Court orders the respondent state to take all necessary measures within 1 year of the notification of this judgment in order to retry the case involving the applicant in a procedure which does not provide for the mandatory application of the death penalty and which upholds the judge's discretionary power. Court orders the respondent state to take all necessary measures within 6 months of the notification of this judgment to expunge from its criminal code, the imposition of the mandatory death penalty. Court orders the respondent state to take all necessary measures within 6 months of the notification of this judgment to expunge from its criminal record hanging as a method of enforcing the death penalty. On the publication of the judgment, the court orders the respondent state to, within a period of 6 months from the date of notification, publish this judgment on the websites of the judiciary and the Ministry for Constitutional and Judicial Affairs, and to ensure that the text of the judgment is accessible for at least 1 year after the date of publication. On the implementation and reporting, the court orders the respondent state to submit to it, within 6 months from the date of notification of this judgment, a report on the status of implementation of the measures ordered herein, and thereafter every 6 months until the court considers that all the measures have been fully implemented. On course, the court orders that each party bears its own course. Signed, Modibo Sako, Vice President, Rafa Benashur, Judge, Susan Mengwe, Judge, Tujelani Chismela, Judge, Shafika Bensaula, Judge, Blaise Chikaya, Judge, Stella Anukam, Judge, Tumisabibu Nzebeza, Judge, Dennis Dia J, Judge, Dangus Kaswaga, Judge, and Robert Ino, Registrar. Now, in accordance with Article 28, brackets 7 of the protocol and Rule 70, brackets 2 and brackets 3 of the rules of the court, the separate opinion of Judge Rafa Benashur and the declarations of Judge Blaise Chikaya and Judge Dumisa Bin Sabeza are attached to this judgment. That's done at Arusha this 5th day of February in the year 2025 in English and French, the English version being authoritative. I hand down the judgment.
Telle est la décision de la Cour.
Much obliged, my ladies, my lords.
Requête numéro 019-2018, Centre pour les droits de l'homme et autres contre la République unie de Tanzanie. L'arrêt sera lu par l'honorable juge.
(2018). It is a long judgment running into 100 pages with about 500 paragraphs. So I will be reading an extract of the judgment as our usual style. The court is composed of Modibo Sako, the Vice President, Rafa Benashur, Susan Menge, Shafika Bensaula, Blaise Chikaya, Stella I. Anukam, Domisa B. Nsebesa, Dennis D. Ajay, and Duncan Gaswaga, judges, together with Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani D. Aboud, the President of the Court, and the National of Tanzania did not hear this application. In addition, in accordance with Rule 9.4D of the Rules, Justice Tijalin R. Chizomila, recused herself. In the matter of Center for Human Rights, I will be abbreviated as CHR, Institute for Human Rights and Development in Africa, IHRODA, and Legal and Human Rights Center, LHROC, represented by Professor Franz Vijon, Director, Center for Human Rights, University of Pretoria, Mr. Michael Gyan Yako, Deputy Executive Director, Institute for Human Rights and Development in Africa, Mr. Fogans Masawa, Director of Advocacy and Reforms, Legal and Human Rights Center, and lastly, Dr. Shipo Irene Rushwaya, Senior Legal Officer, Institute for Human Rights and Development in Africa. These are the representatives of the applicants, versus the United Republic of Tanzania, represented by Dr. Ali Posi, the Solicitor General, Office of the Solicitor General, Ms. Alice Tulo, Deputy Solicitor General, Office of the Solicitor General, Mr. Mark Mawabo, Acting Director, Civil Litigation, Principal State Attorney General of the Office of the Solicitor General, Mr. Hangi N. Shagyan, Assistant Director, Human Rights and Election Petition, Office of the Solicitor General, Ms. Vivian Method, Principal State Attorney, Office of the Solicitor General, Ms. Naridwa Sekimanga, State Attorney, Office of the Solicitor General, and lastly, Mr. Daniel Yakia, State Attorney, Office of the Solicitor General. The subject of the application. I read the facts of the matter. The applicants assert that the population of persons with albinism in the respondent state is estimated to be more than 200,000, and this is considered to be one of the highest rates per country in the whole world, at 1 in 1,429 persons. It is submitted that throughout history, the persons with albinism in the respondent state territory have endured persecution and humiliation, resulting in mutilations and killings. The applicants further aver that the substratum of the attacks on the persons with albinism is particularly located in tribal beliefs and practices, some of which characterize children born with albinism as a cause. Therefore, killing of the children was perceived as an act of cleansing the community of the cause. Other beliefs related to the persons of albinism are that they are ghosts, thus they never die, and having sexual intercourse with a woman with albinism can cure AIDS. Body parts of persons with albinism can be magically used to generate wealth. And when a child is born with albinism, it is the mother's fault. Furthermore, the applicants assert that as a general practice, the assailants of persons with albinism, they target their body parts when they are alive, desecrate the graves of those who are deceased, dismember their bodies and steal their parts, mainly for witchcraft purposes. The applicants submit that robbery of body parts in the respondent state territory have been reported along with outright human trafficking of persons with albinism. The applicants further aver that from the year 2000 to June 2016, the total number of deaths in the respondent state territory was 76, while the number of survivors of attacks and kidnappings were 69. According to the applicants, as persons with albinism are a minority population, such high numbers are indicative of a serious and widespread threat to their very existence. It is also the applicant's assertion that most persons with albinism have meager job prospects. The situation forces them to take up menial jobs, which further exposes them to ultraviolet radiation from the sun, making them susceptible to skin cancer. The applicants aver that with these conditions, most persons with albinism in the respondent state territory have difficulties accessing essential social services. According to the applicants, nearly 70% of victims of mutilations and killings of persons with albinism are children, as they are seen as easy targets and also considered to have innocent souls, more suitable for magical purposes of wealth generation. It is the applicant's contention that children as young as 7 months have been killed or mutilated in order for the perpetrators to extract their body parts. The alleged violation. The applicants allege violation of the following. 1, the right to life protected under Article 4 of the African Charter. 2, the prohibition against torture, degrading and inhuman treatment under Article 5 of the Charter, Article 7 of, and also Article 7 of the International Covenant on Civil and Political Rights, hereinafter referred to as the AfCHPR, and Article 16 of the African Charter on the Rights and the Welfare of the Child, hereinafter referred to as the Children's Charter. Thirdly, the prohibition of sale, trafficking and abduction of children under Article 29 of the Children's Charter. Fourthly, the right to dignity protected under Article 5 of the Charter. Fifthly, the right to non-discrimination protected under Article 2 of the Charter. And lastly, the right to an effective remedy guaranteed under Article 7 of the Charter. Prayers of the party. With regards to the merits, the applicants pray the court to find that the respondent state has violated the rights stated in paragraph 12, namely Article 2, Article 4, 5, 7, and 29 of the African Charter. With regards to reparations, the applicants pray the court to order the respondent state to, 1, adopt a comprehensive national strategy so as to eliminate attacks against persons with albinism. 2, diligently investigate and prosecute perpetrators of attacks against persons with albinism. Thirdly, reform its criminal law to classify crimes against persons with albinism as hate crimes with enhanced penalties. They equally are demanding to assemble a committee of government officials, civil society representatives, persons with albinism or their representatives to identify victims of attack, compensate them according to the extent of their injuries, and provide them with rehabilitation measures. Fifthly, provide adequate housing to the families of persons with albinism which have had to flee their homes as a result of attacks on them or their children. Sixthly, enjoy that the children affected by attacks against persons with albinism are provided with special educational and vocational assistance programs. Seventhly, ensure that holding centers for children with albinism are conducive for growth and development and plan for a long-term reintegration with their families. Eighthly, carry out nationwide sensitization of the public to dispel unfounded myths about persons with albinism. Ninthly, provide effective training to law enforcement officials, prosecutors, and judges on the effective investigation and prosecution of offenses committed against persons with albinism. 10th, to set up a fund for advocacy and services in the interest of persons with albinism, with participation of persons with albinism in its design, establishment, and implementation. And lastly, to provide other symbolic reparations as the court deems appropriate. With respect to jurisdiction and admissibility, the respondent state praised the court for the following. 1, that the Honorable Court is not vested with jurisdiction to adjudicate over the matter. Secondly, that the application has not met the admissibility requirements stipulated under Rule 50 sub 2E of the Rules of Court. And lastly, that the application be declared inadmissible. With respect to the merits of the application, the respondent state praised the court for the following. 1. A declaration that it did not violate the right to life, dignity, and effective remedy of persons with albinism, protected under Articles 4, 5, and 7 of the African Charter. 2. A declaration that it did not violate the right to freedom from torture, cruel, inhuman, or degrading treatment, protected under Article 5 of the Charter, Article 7 of the AfCHPR, and Article 16 of the Children's Charter. Thirdly, a declaration that it did not violate Article 29 of the Children's Charter. And fourthly, a declaration that it did not violate Article 2 of the Charter and Article 3 of the Children's Charter. Fifthly, dismiss the application with cost. And lastly, dismiss the prayers on reparation as being baseless, misconceived, and untenable. I will now proceed to read the operative part of the judgment after due consideration and deliberation. For these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction, declares that it has jurisdiction. On admissibility, the court dismisses the objections to the admissibility of the application, declares that the application is admissible. On the merits, the court holds that the respondent state has not violated the right to an effective remedy guaranteed under Article 7 of the Charter, as read jointly with Article 1 of the Charter. The court further holds that the respondent state has violated Article 1 of the Charter with regard to failure to give effect to the rights in the Charter as it relates to persons with albinism. The court also holds that the respondent state has violated the right to non-discrimination guaranteed under Article 2 of the Charter by failing to put up sufficient measures to combat myths and stereotypes relating to albinism. The court further holds that the respondent state has violated the right to life protected under Article 4 of the Charter and Article 6 of the AfCHPR for failing to take sufficient preventive measures and also for failure to effectively investigate and punish the perpetrators of killings of persons with albinism. The court also holds that the respondent state has violated the right to dignity under Article 5 of the Charter, as well as the freedom from torture, degrading and inhuman treatment under Article 5 of the Charter and Article 7 of the AfCHPR by failing to protect persons with albinism from attacks and persecution occasioned on account of their albinism. The court also holds that the respondent state has violated Article 29 of the Children's Charter by failing to prevent the sale, trafficking, and abduction of children. The court further holds that the respondent state has violated Article 4 of the Children's Charter by not taking into consideration the best interest of the child in the operation of shelters devoted to children with albinism. The court also holds that the respondent state has violated Article 17(1) of the Charter by failing to ensure that education is available, accessible, acceptable, and adaptable to the needs of persons with albinism. The court holds that the respondent state has violated Article 16 of the Charter by failing to provide persons with albinism with the best attainable standard of health. On reparations, I start with the pecuniary reparation, under which we have the material prejudice. The court orders the respondent state to establish a compensation fund within 2 years of notification of this judgment and in consultation with the applicants and the representatives of persons with albinism, identifying victims of attacks and compensate them according to the extent of their injuries. On moral prejudice, the court orders the respondent state to pay within 2 years of the notification of this judgment into the compensation fund the sum of 10 million Tanzania shillings for the moral prejudice suffered by persons with albinism, which will also be the seed money to the compensation fund. On non-pecuniary reparation, the court dismisses the prayer for other symbolic reparation. The court orders the respondent state to amend its existing laws within 2 years of notification of this judgment in order to criminalize and punish acts of violence that target persons with albinism, treating such acts as having been committed under aggravated circumstances. The court orders the respondent state to amend the Witchcraft Act 1928, Chapter 18 of the laws of Tanzania within 2 years of notification of this judgment in order to clarify ambiguities in relation to witchcraft and traditional health practices. The court also orders the respondent state to, within 2 years of notification of this judgment, to finalize, promulgate, and implement its national plan on the promotion and protection of the rights of persons with albinism in conformity with the African Union Plan of Action to end attacks and other human rights violations targeting persons with albinism in Africa, 2021 to 2031. The court also orders the respondent state to take all necessary measures within 2 years of notification of this judgment towards the full realization of the right to education as it concerns persons with albinism. The court also orders the respondent state to take all necessary measures within 2 years of notification of this judgment towards the full realization of the right to the best attainable standard of health. The court further orders the respondent state to take necessary steps within 2 years of notification of this judgment to raise awareness on the myths regarding albinism through far-reaching campaigns sustained continuously for at least 2 years. The court further orders the respondent state to formulate and execute strategies within 2 years of notification of this judgment that will ensure the full realization of the rights and welfare of children with albinism. This will, inter alia, include initiatives on their security, psychosocial, medical, and other assistance critical to their survival and development. The court also orders the respondent state, in cooperation with the applicants, to facilitate a comprehensive and coordinated effort within 2 years of notification of this judgment to reduce shelter overcrowding, reunite families, and ensure that children with albinism in these shelters have access to basic services. The court also orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the Prime Minister's Office, Labor, Youth and Employment, and Persons with Disability, Judiciary, and the Ministry for Constitutional and Legal Affairs, and to ensure that the text of the judgment remains accessible for at least 1 year after the date of publication. On implementation and reporting, the court orders the respondent state to submit to it within 2 years from the date of notification of this judgment a report on the status of implementation of the decision set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. The court also on implementation and reporting, the court holds that it shall conduct a hearing on the status of implementation of the orders made in this judgment on a date to be appointed by the court within 3 years of the date of the notification of this judgment. On cost, the court orders that each party shall bear its own cost. This judgment is signed by the bench as earlier mentioned, and in accordance with Article 28(7) of the protocol and Rule 71 of the rules, the separate opinion of Justice Blaise Shikaya is appended to this judgment, and this judgment is done at Arusha this 5th day of February in the year 2025 in English and French, the English text being the authoritative text. Merci, Monsieur le Président.
Telle est la décision de la Cour. Requête numéro 25-2018, Boniface Alisteres contre la République unie de Tanzanie. La décision sera lue par l'honorable juge Duncan Gaswaga.
Thank you, Mr. President. In the matter of Boniface Aristide, application number 018-025 of 2018, judgment of 5th February 2025. The court, composed of Modibo Sako, Vice President, Rafa Benahue, Susan Mengi, Tujirani R. Chizumira, Chafika Bensula, Blaise Chikaya, Stella I. Anukam, Dumisa B. Ntebeza, Dennis D. Ajay, Duncan Gaswaga, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9, Sub-Rule 2 of the Rules of the Court, hereinafter referred to as the Rules, Justice Iman D. Aboud, President of the Court, and the Nation of Tanzania did not hear the application. Subject of the application. Facts of the matter. It emerges from the record that on the 14th of September 2013, the applicant was arrested and charged with the offense of rape of a 17-year-old minor and sentenced to 30 years in prison by the Magistrates Court of Mwanza, Tanzania, in criminal case number 19 of 2014 on the 12th of February 2014. Aggrieved with the decision of the Magistrates Court, the applicant appealed to the High Court of Tanzania at Mwanza, which dismissed his appeal on 13th April 2016. Dissatisfied with the judgment of the High Court, he further appealed to the Court of Appeal at Mwanza, which similarly dismissed his appeal for lack of merit on the 13th of April 2018 and upheld the conviction and sentence in its entirety. Prayers of the parties. The applicant prays the court to make the following findings and orders. 1, find that the court has jurisdiction to determine the matter. 2, find that the application has met the admissibility requirements stipulated under Rule 40, Sub-Rule 5 and 6 of the Rules of the Court. 3, find that the respondent state has violated Article 2, Article 3, 1, and 7C of the Charter. Order the respondent state to nullify its decision and order his release from prison. Order the respondent state to provide reparations for the violations established. And finally, order any other relief or remedy as the court may deem fit. With respect to reparations, the applicant prays the court to 1, grant him United States dollars 11,520 for the material prejudice suffered since he was arrested, and to grant his beneficiaries and indirect victims a total sum of United States dollars 95,000. To order the respondent state to pay him United States dollars 72,000 for moral prejudice suffered, calculated at United States dollars 1,000 per month from the day he was arrested on 14 September 2013 to the date of filing his application on 3rd November 2018. And 3, order the respondent state to pay him United States dollars 77,000 for his dependents as indirect victims for moral prejudice suffered. With respect to jurisdiction, admissibility, and merits, the respondent state prays the court to 1, declare that the court is not vested with jurisdiction to adjudicate on the application. 2, declare that the application has not met the admissibility requirements provided for under Article 56 sub Article 5 of the Charter, Article 6 sub Article 2 of the Protocol, and Rule 50 sub Article 2E of the Rules of the Court, and it is therefore inadmissible and be duly dismissed. 3, declare the application inadmissible and dismiss it with costs. 4, make an order that the respondent state did not violate the applicant's human rights provided under Article 3, Sub-Article 1 and 2, and 7C of the Charter. Order that the respondent state did not violate its obligation under Article 1 of the Charter. 6, find that the applicant was tried and convicted in accordance with the laws of the respondent state and international human rights standards. 7, dismiss the application for lack of merit. 8, dismiss the applicant's prayers. 9, dismiss the applicant's prayers for reparations. And finally, 10, order that the costs be borne by the applicants. Operative part of the judgment. For these reasons, the court on jurisdiction unanimously, 1, dismisses the objection to its material jurisdiction. 2, declares that it has jurisdiction. On admissibility, dismisses the objection on exhaustion of local remedies and declares the application admissible. On merits, the court holds that the respondent state did not violate the applicant's right to a fair trial guaranteed under Article 7, Sub-Article 1C, regarding his conviction and sentencing on evidence not proved beyond a reasonable doubt. The court also holds that the respondent state violated Article 7, Sub-Article 1C of the Charter, as read together with Article 14, Sub-Article 3, Sub-Article 3D of the ICCPR, with regard to its failure to provide free legal representation to the applicant. On reparations, first, pecuniary reparations. The court dismisses the applicant's prayers for material damages. The court also dismisses the applicant's prayers for pecuniary reparations for his dependents as indirect victims. The court grants the applicant's prayer for reparations in respect of the moral prejudice as a result of the violations established under and awards him the sum of T shillings 300,000. The court orders the respondent state to pay the sum awarded under 9 above, free from tax, as fair compensation within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the amount is fully paid up. On non-pecuniary reparations, 1, the court dismisses the applicant's prayers to set aside his conviction and sentence and orders his release. 2, orders the respondent state to take all necessary constitutive and legislative measures within a reasonable time and in any case not exceeding 2 years to ensure that the Legal Aid Act 2017 is amended and fully aligned with the provisions of the Charter and ICCPR. On publication of the judgment, the court orders the respondent state to publish this judgment within a period of 3 months from the date of notification on the websites of the judiciary and the Ministry for Constitutional and Legal Affairs, and ensure that the text of the judgment is accessible for at least 1 year after the date of publication. On implementation and reporting, the court orders the respondent state to submit to it, within 6 months from the date of notification of this judgment, a report on the status of implementation of the orders set forth herein, and thereafter, every 6 months until the court considers that there has been full implementation thereof. On costs, the court decides that each party shall bear its own costs. Signed by Modibo Sako, Vice President, Rafa Benaju, Judge, Susan Mengi, Judge, Tujirani R. Chizumira, Judge, Tafika Bensula, Judge, Blaise T. Chikaya, Judge, Stella I. Anukam, Judge, Dumisa B. Sebeza, Judge, Dennis D. Ajay, Judge, Duncan Gaswaga, Judge, and Robert Eno, Registrar. Done at Arusha, this 5th day of February in the year 2025 in English and French, the English text being authoritative. Thank you, Mr. President.
Telle est la décision de la Cour. Le rôle de ce jour étant épuisé, la présente audience est levée.
Okay, thank you very much for coming. You are all invited for light refreshments outside, and bon appetit.